All right. Well, let's get it going. Let's get it going. Um, Welcome everyone to the second event in ASMP's 80th anniversary set of events, which we're going to be talking all about. I am thrilled to get going with the presentation with Scott Burroughs, who's going to be out here in just a second. But before we did that, we have something a little special for you, a little treat. We have Grayson Danzig here with us. He is ASMP's the archivist, and we are thrilled to have him. He's going to tell us a little bit about a few things that we're going to look at right here at the top. And I think you might enjoy them just as much as I do. Let me go ahead and share my screen for a quick second as I go over just a few announcements and things that we have going on here. First of all, thank you again for coming tonight. We're really happy to have you. We're going to talk about some really interesting stuff. And before we do that, we're going to talk about the fact that this is ASMP's 80th anniversary. We are so excited to celebrate this. And we are having 8 weeks of celebration, 8 weeks over which we're going to be having 8 events, 4 in person and 4 virtual events. We're going to be having giveaways. We're going to be going into the archives. We're going to be doing a whole lot of other exciting stuff that is brand new, and we're really looking forward to it. This is the second of those 8 events that are going to take place between October and December of this year. If you are in the New York City area, you definitely want to mark your calendars for December 5th. December 5th is going to be a day-long celebration of all things ASMP. It is the capstone to this 8 weeks of incredible activity, and we hope you're there. And if you can't be there in person, we know you'll be there in spirit. It's going to be a lot of fun. Now, if this is the first time you've heard about the ASMP 80th anniversary, fear not, because we have created a brand new site just for you. Give me 1 second to share my screen, and we will go over to it. And that's over here at asmp80th.org, asmp80th.org, 80th.org. And once you're here, you can scroll down and read some of the history of ASMP, learn about what we're doing, learn about the events that we have going on. One of the most important and rewarding parts of celebrating the 8th anniversary is thinking about the history of ASMP. And that's where Grayson comes into the mix. And here on the 80th mini site, we have Explore the ASMP Archives, where we're going to be updating the website with new materials each and every week. There's a video here of Grayson in the archives you can watch. But down here under Explore the Archive, you can take a closer look at some incredible documents, some of which we're going to look at right now. And again, these are going to continue. We're going to continue to add to them as we move forward in the 80th anniversary. But today, we wanted to look at 3. Isn't that right, Grayson? I think there were 3
Yes, sir.
that we wanted to pay attention to. And so let me get those up here. Give me 1 second. Now, where did you go? There we go. Okay. And these documents are also over on the 80th mini site. But Grayson, we're looking here at something that's a certificate of incorporation of Society of Magazine Photographers, Inc. from December of 1944. Can you just give us a quick couple-minute history on ASMP at that time and how it came to be and how this document came into existence?
Well, thank you so much, Thomas. It's an incredible honor and privilege to be speaking to you. One of the great things for me is my connection to ASMP over the years, and it certainly is the coolest thing to be talking about the archives, which I've had the privilege of working with. We're almost on and off for 7 years now. As everybody knows, ASMP started in 44, but there was earlier meetings even in 42 while the war was still going on. But the quote that I always come back to is by one of the founding members, Bradley Smith. He says, it was the year of 1944, a year of beachheads of Normandy, the beginning of the end of World War II. And it was also the year of the first meeting to organize photojournalists, a new breed of concerned visual communicators. It's an unbelievable document that we have in the archives there. And I actually have the information that there was a meeting on the 12th of October. There were some notations written by Nelson Morris, who was ASMP member 19, saying that on the 12th of October was one of the earlier, the official first meeting that took place. The incorporation document that you have is from December 22, 1944. And there are all the signatures of Bradley Smith, John Adam Knight, Nelson Morris, Philippe Halsman, and Alan Gould, and each one of them having distinguished careers in and out of ASMP. It's just such a great wealth within the documentation of ASMP archives that you're able to research and find the conversations and the invitations to go further. Philippe Halsman, for example, was ASMP member number 1. Okay, he originally starts out as a secretary and was very modest, but did accept the first and then later the third presidency for ASMP. We're honored. But the official first temporary president was the first one of the signatures there, John Adam Knight, who was a non-photographer, an amateur chef, and his real name was Pierre de Rohan. And he wrote photography column for the New York Post under the name John Adam Knight. And he was the one back in 1942 who put together the idea with Click magazine photographers Bradley Smith and Ike Verne to get some sort of, a club of something for magazine photographers. And from those early gentle conversations to weekend parties, Bradley Smith's home, they had their ideas together. And, this was the core of people who really wanted to protect and defend the honor of photographers. I mean, the goal of ASMP was stated as to improve the circumstances of working photographers and to safeguard and protect their interests, to maintain and promote the highest standards of performance and ethics, and to cultivate friendship and understanding among professional photographers. I mean,
well,
in simple words, more valiant efforts have never been stated so clearly and so emphatically. And I'm just so honored to be able to bring to light these documents that pretty much have been sitting, waiting to be discovered.
And seen, yeah.
And the 80th is the perfect time, to talk about and to see where we're going and to see how, the fight continues with AI and everything that you mentioned earlier. Yes.
Well, thank you, Grayson. And one of the cool things is that ASMP has had such incredible members over the years, and I think there's a name that almost every photographer knows, and that's Henri Cartier-Bresson. And of course, he was an ASMP member. Isn't that right?
Absolutely. And the greatest thing for me, on a personal note, is Henri Cartier-Bresson was an ASMP member 605, joined in 1956. Well, ASMP member 606 was my beloved late father, Jerry Danzig. And I found that out in my work with you guys as your archivist and now historian. And it was one of the great pleasures of my life to realize that, rubbing shoulders with the great ones, so it's a cool thing to know. I mean, this letter here from 57, which is the great quote of the hows are not important. It's the outcomes that count. The results have to mature in silence with a certain amount of secrecy.
Oh, did we lose Grayson?
And this is
I don't
5
know.
years later, right? What I also noted, by the way, in 56 was another letter that I'll just let you know about, just because I love the quote. The quote is from Cartier-Bresson when he was asked to join in 56. And he says, "I am much honored for your proposal. I never belonged to any club, nor did my camera, but my trigger finger cannot resist your suggestion." I mean, this is a man who was one of the founders in 1947 of Magnum, along with Robert Capa, who we lost too early during the war, David Seymour, William Vanderbilt, George Roger, and they all together in 1947 founded Magnum. And so you see it's on Magnum stationery. So the weight of this document in front of us is incredible within the spectrum of, here is one of the founders of Magnum saying something so glorious.
Well, I think it's incredible. We're going to continue to dive into the archives, but before we let you go, Grayson, we wanted to pull up one of the really unique things about ASMP is that it has member files going all the way back to 1944, and all of these member files from back in the day had handwritten applications to become a member of ASMP. And here is Arnold Newman's application submitted in July of 1946, so just a couple years after the formal incorporation of ASMP. And I know you could talk for days about Arnold Newman and ASMP, but do you want to just
Yeah, I
make a
mean, I
note or
can
two
give
here?
you, I mean, right. So Arnold Newman was ASMP member 181. And what one of the things that I was doing today, when of course he's proposed by Elliot Ellisoffen, legendary photographer, who I just spoke with his daughter, and told me the whole story, by the way, of how they were introduced. They met in Florida, where Ellisoffen borrowed Newman's darkroom and convinced him to come to New York because he needed to be in New York. And this was just around the time that Newman had a huge show called "What Artists Look Like," or "Artists Look Like This" at the Philadelphia Museum, and there was a big article in Life magazine. So for the friendships that I quoted, as one of the founding ideas of that was the core of, obviously Ellisoffen saw such greatness in Newman, he wanted him on the team. And then of course, he was seconded by Eugene Smith.
I mean,
I mean,
that's
talk about it, making it to the big time. Yeah, and the 1993 interview that I just was listening to with Mimi Leipzig and Carey's was just amazing, because here's Newman talking about the early times like they were just yesterday, and Newman was a genius. He was, and Elliot, by the way, was one of the founding members of the Photo League in 1936. And Elliot was also, by the way, the first VP at ASMP. But yeah, Newman.
Grayson.
Yeah, go ahead.
I feel like I know, because you and I have done it. We could spend hours looking at this. We're going to have you back. We're going to have you back next week at hopefully the next event, and definitely at the archives presentation at the December 5th event, right?
Beautiful. Yeah, well, I'll just leave you with this. Newman, in that interview, I was getting to the quote. I was just finding my notes. He said, "I sort of started at the top." So there you go. There you go.
I love it. I
So
love
much
it.
for your
Well,
time.
Grayson, thank you.
Okay.
Okay. And thank you, Grayson, for your time. And I'm going to invite out Scott Burroughs, our co-presenter today, to hop out front. Hey, Scott, how you doing?
I'm doing well. Thank you for having me. I'm honored to be part of the 80th anniversary celebration and look forward to a great chat.
Oh, well, we're so happy to have you here, and I'm just going to wrap up the tail end of this, and I'm going to implore all of you to don't forget to go and register for those giveaways, because we want to give you stuff. That's the goal, and we got some really cool stuff to give you here in the next little bit. So today, Scott and I are going to talk about three big areas: copyright, generative AI, and the Supreme Court. And, these areas mix and mingle with each other. But before we jump into that, I wanted to take a note and one, again, express my appreciation to Scott. Scott has worked with and on behalf of ASMP members for many, many years now, and is one of the attorneys that has most championed the causes of photographers and creators, and is such a stalwart champion for copyright owners. So it's a real pleasure to have Scott here, and I am proud to say I've worked with Scott on a number of different cases, either in support as a writing amicus briefs, as we'll look at in a little bit, or just from the sidelines watching the work that he does. So it is a joy to have you, Scott. We're really happy to have you here. Okay, let's take a look here. I'm going to go ahead and All right, let's see here. Okay, hopefully everyone can see that. And we are going to go ahead and jump in and get started. So we wanted to start with a copyright update. And there were some questions that have come in, and they're important questions about the Register of Copyright Share Perlmutter. And so we wanted to give a little bit of background as to what's been going on, because there are some developments even incredibly recently on this. So on May 8th of this year, President Trump fired the Librarian of Congress, Carla Hayden. And the Copyright Office sits under the Library of Congress in kind of the organizational structure. And so that happened on May 8th. And then on May 9th, the US Copyright Office released the long-awaited report on copyright in AI, particularly the idea of generative AI and fair use. And then it is maybe no coincidence that the next day, on May 10th, Shira Perlmutter, who was the Register of Copyrights at that time, who released that report, was fired by the administration. And so you might be asking yourself, well, what prompted all of this, right? What prompted all of this to happen? And, there are plenty of things that you could plausibly say led to this. However, I would say that there's a direct line that can be drawn from the report that was released. And why was that direct line drawn? Well, there are lots of things in this report, but I'm going to focus in on one of them in this second part of this quote, which is where the US Copyright Office is talking about generative AI and using copyrighted works as part of the training materials for creating the large language models that generate this work. And so this report said in its conclusion, but making commercial use of vast troves of copyrighted works to produce expressive content that competes with them in existing markets, especially where this is accomplished through legal access, goes beyond established fair use boundaries. Now, I'll stop there for a second and say, Scott, I think all of us in the copyright world were keeping an eye on this report when it was coming out, because it's there are lots of different elements that we look at with fair use. But can you talk a little bit about not only this report, but the idea of fair use in generative AI?
Yeah, absolutely. Because after that report came out, a couple of decisions or a handful of decisions have now come down, and they're not all that inconsistent with what is in the USCO report. In each of the cases, the artists, whether they be writers, photographers, musicians, have made these allegations that the use of their content to either train or create content for the large language models is a violation of copyright. And when we look at a violation of copyright, we look at the 106 rights. And none of those rights tracks directly on to AI use, right? The 106 rights that you all have as artists, you have the exclusive right to reproduce your work, to distribute your work, to create derivatives from your work, and so forth. But here, arguably, the large language models were creating unauthorized derivatives because it was taking the underlying content, broken down into data and tiny little pixels, and then reaggregating them to create a new work based on the prompt. And generally speaking, when you're looking at a derivative work in a normal copyright case, you compare it to the underlying work and you look for substantial similarity, or you look for a taking from the underlying work. But here, as the courts have noted in a couple of the cases that have come down, these works often bear little to no resemblance to the underlying work. And so it doesn't fit within that framework that we usually use to establish a copyright infringement claim. And what the courts have done then is to look at sort of the intake process. How are these folks obtaining the copyrighted material? Are they doing it lawfully or through shadow libraries or unauthorized sources? Are they using it with consent or without consent? And are they making copies of it, or are they simply crawling it or reading it without making a copy? And in the Bartz case, and I know Tom will we'll get to this eventually. We'll talk about it a little bit in detail. The courts, looked at those two processes and then mapped it onto a fair use defense, where really, as we know from the Warhol case and others, market harm is really important. And so the courts will be looking at transformation and market harm and weighing the equities and trying to figure out, and it's not easy, what wins out.
I agree with what you said, Scott, and I'll put it into the same nutshell that that we've been arguing here at ASMP, since all of this came to the fore, and that's, we are on the tail end of the greatest theft of intellectual property in the history of the world, right? These creators are not asked for their permission to be used in this training material, and when the Copyright Office came out with a report that said, look, it's about, as you noted, Scott, it's about how you access this work and what, the different market harms that result from this work. It was grudgingly positive for creators in a lot of ways. And so it was disheartening when the very next day, Registrar Perlmutter was fired. And so where are we now? Well, she was fired on May 10th, and on May 22nd, she sued the administration, and she lost in the district court. But just on September 10th, so almost exactly a month ago, the U.S. Court of Appeals for the District of Columbia Circuit upheld her or granted her injunction, and she is back at work. But as Scott noted when we talked about this previously, back at work is interesting because they're all not back at work since the government is shut down. However, she is back in her position, and we will see what happens. We will see what happens if that ruling is appealed by the administration to the U.S. Supreme Court, as many different rulings have been lately, and then see what the result is. But it has been a whirlwind few months for the Copyright Office and for Registrar Perlmutter. So we want to talk about some of the copyright questions that you have. And this brings up a good time to note that at the bottom of your screen, you'll see a Q&A box. And that Q&A box allows you to ask questions that, as we're going through tonight's talk, that we will endeavor to answer. Invariably, by the end, there are more questions than we have time to answer, but definitely want to see if we can answer some of your questions. So please use that Q&A box. If you put them in chat, it's liable we won't see them. So if you use the Q&A box, that is the best way to get our attention with all the various things that we are talking about. But as you know, if you registered for tonight's event, you were asked if you had any questions. And so we selected a few of those questions that Scott and I are going to discuss and answer. And they're just a couple here. And the first one goes to what we were just talking about with Registrar Perlmutter. And it says, since the firing of Shira Perlmutter in June, registered copyrights are being processed without the signature of the Copyright Office's register. Is this a problem? And I'm going to throw that to Scott to answer first.
Yeah, and so it's interesting, right? With the Copyright Office shut down and not working. I mean, I know I've reached out to them recently about an issue, and they responded, or someone responded, or a robot responded saying, "No one's here. We're not working." But when the Copyright Office reopens and starts processing applications again, we will look to see whether that signature is there. But when we began to research the issue, because we know that when you have an infringement case, the defendants will take any chance to sort of avoid liability, not based on the merits, but by pointing out technical issues like issues with the registration. We looked at Section 410 of the Copyright Act and what that has to do with the certificates that are issued by the Copyright Office. And interestingly enough, they do not require a signature. There's nothing in the statute requiring a signature. But there does seem to be an indication that the register has to approve it. And so there may be some question as to whether or not the register approved some of these without signature. But at the end of the day, I don't believe anyone's going to be able to say this registration doesn't comply with the 410 and 411 requirements, because the Copyright Office, per its normal course, reviewed the work and issued the certificates. And so everybody should still be out there registering earlier and as often as they can. Registration is such an important thing. It's often the deciding factor for our firm and lawyers like our firm, or at firms like our firm, where registration may make the difference between whether an attorney can help you on a contingency basis or not. And so hopefully it's the part of everybody's workflow here. And it's not that hard. You can do it quarterly. You can include up to 750 selects or important works on a registration. But hopefully everyone is registering their work. So when you call me or Tom or somebody with an issue, and we ask you as our first or second question, do you have a registration? You can say yes.
That is so important. And if you have been an ASMP member for more than a month, you have heard me probably say this 100 times. And what Scott noted a point that I think is really critical to understand, and that's if a work is not timely registered, you are not eligible for both statutory damages and attorney's fees. And what Scott was noting is that it's very hard sometimes to find an attorney to take a case, especially a small case, if it hasn't been registered properly, because the incentives for both the creator in the term of statutory damages and the attorney are not present. And so it's like insurance for your business and your future. You want to go ahead and get those works registered. It really does make a huge amount of difference, and something that both Scott and I are very passionate about and care about. And we do see a lot of great questions coming in, and this is wonderful because we're going to leave some time at the end to answer those, as well as all throughout the presentation, like we're doing right now. So, there's let's see here. There's a question here, Scott, that is a little bit different from the ones that we've been looking at. And it said, do my heirs designated in my will automatically inherit my copyrights, or does that have to be spelled out in the will? And I know that you are not a trust and estates attorney generally, but I know that you do often deal with copyrights when it comes to how they pass down through heirs and businesses and everything else. What are your thoughts about this?
Yeah, it's funny. Actually, I have a case involving this exact issue right now where this is being litigated, and it raises a couple of interesting issues. The first of which is maybe not apparent to all artists, even those that are smart enough to join a panel like this. But the only way under the law, generally speaking, to transfer ownership of a copyright is by signing a written document. It's in section 203 of the Copyright Act, where it says, and Congress did this on purpose to protect artists, that says that, look, if a third party is going to claim ownership of your copyright, they have to show a writing that you signed transferring it to them. And so even if you do, a commissioned work, if you are paid for a particular work, you still own the copyright until you sign a writing saying otherwise, or if you create it as an employee in the scope of your employment, things like that. But the one exception, or one of the few exceptions to that, is the ability to bequeath copyrights by will, or even if someone passes away intestate without a will. And so if you own copyrights, or somebody above you in your family lineage owned copyrights and passed away, those will pass as part of the corpus, as part of the estate. And if they are singled out specifically, that's fantastic. That makes it easy. Oftentimes, intangible assets are not singled out, and so they fall into a sort of what we call a spillover clause, or a clause that gathers up the rest of the things that aren't specifically laid out in the will, or they're just distributed, either pro rata or in other ways that I won't get into because it's a bit boring in wills and trusts. But yes, to answer your question, they will pass in either via will or via intestacy.
And I think that, and I'm sure Scott runs into this all the time as well, a lot of people both don't think about this, especially family members who are not the creators or the owners of the copyrights, and there haven't been any discussions about this. And so, these copyrights that rightfully should be passed down in the way that all other intangible assets would be, are somewhat forgotten in the mix. And so it's worth having those conversations with your family and your heirs to talk about what happens with copyrights in general, even if they're not specifically spelled out in the will. And this reminds me of something that I often say, which is, copyrights are a form of intellectual property, but intellectual property is property. It's property under the law. And so, yes, it will pass down. You just have to treat it a little bit differently than you might, something that everyone can see and touch and feel, even though it has value of the same. So thank you for that
And
question.
you can take steps now to assist your heirs with that. You may have more than one child, one of whom is a little bit more business minded than the others. So you may set forth in your will that child A will be charged with administering the intellectual property, and then they'll share the revenues with child B and C, or however you want to structure it. But doing that now, as opposed to just having them address it later, it's preferable.
Well, let's cross the border here, Scott. I am not licensed in Canada, but we do have a question about copyrights and international exposure. As a U.S. born photographer working on both sides of the U.S.-Canada border, but living in Canada, would it be wise to register images for copyright on both sides of the border? My basic assumption is always that the USA will consider me American above all else and primarily subject to US jurisdiction and laws. What do you have any immediate thoughts on this?
Yeah, absolutely. Because this raises a number of interesting and also counterintuitive issues. The first of which is that as a Canadian photographer working in Canada, if you're also publishing in Canada, you counterintuitively don't need to register your work. You can file a case in the United States without a registration. The US is really the only jurisdiction where registration is required. And the counterintuitive part is that an international photographer who publishes a work international and then has it infringed is able to go to court here in the States and file a claim without first registering. But if you're a US resident that's publishing the US and that work's infringed, then you do have to first obtain the registration.
And, I want to piggyback off of what you just said, Scott, because this goes into the work that ASMP does on the advocacy side. So I was just in Washington about a month ago, and over the course of 2 days, met with 8 different senators and Senate offices where we're talking about a new bill that we hope the Congress will take up regarding modernizing copyright registration practices. And in the beginning of those conversations, almost invariably, the way that I open those conversations is I say, the United States is the only country in the world that requires registration before the full force of the protection of copyright law can apply. And if you're going to require someone to register, you have to make it easy. You have to make it cost effective. And the system is not easy and not cost effective for large quantities of images now. And it goes to exactly what we're talking about. So as Scott said, counterintuitively, you may have additional protections based on the fact that you're in Canada that you might want to take advantage of. Now, a little bit of a history lesson. Certainly, if you are an ASMP member, you can go over to the ASMP Academy and watch the history of copyright video that I did a number of years ago now, where we talk about the treaty that all of these countries signed, the Berne Convention, where BERNE, where the different countries came together that recognize the validity of copyright laws of creators, as between countries. That's a really important document and a really important treaty that still exists today. And often when I was in private practice many years ago, there are only a few countries that are not signatories to that treaty. And if you happen to be infringed by one of those countries, it was a much harder uphill climb to do anything about it. And so if you want to dig into that more, there are videos over there in the ASMP Academy that you can take a look at. Okay. Well, we're going to come back to questions. And please continue to put questions in the Q&A box. Some of the questions that have been put in, I know, will touch on things like AI, which we're about to start talking about. So I'm going to share my screen one more time, run through a few things, and then we will continue.
And while he's doing that, just to put a button on the last conversation, the photographer in Canada, you should still register your work in the States, because even though you don't have to, that will enable you to obtain statutory damages and attorney's fees if you obtain that registration either before the infringement or within 3 months of when you publish the work.
Thank you, Scott. Thank you for doing the important work of reminding people to register and why they should. It is critical for everyone. Now, there is something that we are lucky to have here, and that is for all the reasons we talked about, it's great to have Scott Burroughs here. But Scott Burroughs has also argued copyright cases in front of the U.S. Supreme Court, and one in particular, ASMP, was particularly involved in. And this is the case of Unicolors versus H&M. And this goes to some of the things we were just talking about on copyright registration applications. And if you want to dive into the nuances of this case, unless you find detailed copyright statutory interpretation interesting, as I do, and I believe as Scott does, you may want to just get to the upshot, which is this is one of the most important rulings that's come out in recent years for creators. And it is a privilege for all of us to have someone like Scott who argued this at the U.S. Supreme Court and had been working on this case for years here with us today. This all has to do with this section of law, this 411B section, which talks about that a certificate of registration satisfies the requirements, regardless of whether the certificate contains any inaccurate information, unless the inaccurate information included on the application for registration with knowledge that it was inaccurate and the inaccuracy would have caused the Register of Copyrights to refuse registration. And if you thought that sounds a little confusing, it was, and that's what the court thought too, which is why the court takes up these cases, is to help clarify these areas of law. And so, Scott, can you, in a nutshell, give us the background of Unicolors versus H&M, and then we'll get to kind of what the results were?
Sure. Yeah, this case addressed a longstanding problem, and I mentioned it, referred to it earlier, where you have these situations where the United States is the only country that requires a copyright registration, and not only is it required, but it's a fundamental element or part of the claim. And so you had a number of cases where artists and copyright holders were suing infringers, and it was clear from the evidence that there was liability, that they had taken the work and used it without consent, but they were able to evade liability by saying, well, the plaintiff's copyright has a typo in it. They checked a wrong box, or they said the work was published when it wasn't. All these small errors that folks that are artists that are filling these forms out make all the time, because the forms are straightforward and short, but they're not the most user-friendly. And so we had a situation where a fashion designer in Los Angeles had completed one of these applications years and years ago. And there was never any issue with it. But then we got into court and we were suing the large retailer H&M. We went all the way through a jury trial and we had won. And the jury had found for us basically on everything. But then thereafter, the folks at H&M said, oh, wait a minute. When they filled out this copyright registration 10 years ago, they made an error in it. And so the result should be overturned. And at first, the circuit court, the appellate court said, okay, that seems to be the law in this circuit. And we petitioned the Supreme Court, who looked at it and said, this is absurd. These are formalities or technicalities. This registration doesn't affect the copyrightability of the work. And again, we always find that folks tend to conflate copyrightability and registrability. As a creator, you own a copyright in your work as soon as you click the shutter button and fix the work. That copyright exists from the moment of creation. But registration is its own thing, and it's something that the courts require us to do before we go to court. It used to be, before another Supreme Court case, that you could apply to register your work and then go to court. But now you have to apply, wait for the Copyright Office to rule on your application, which when they're not open, may take some time. And then once the certificate comes out, then you can make bring your case in court. But when we got to the Supreme Court, we argued, the practicality of it, where look, these are artists filling these things out, oftentimes without the assistance of lawyers, and they're all doing their best. And unless they're really trying to defraud the Copyright Office, right? If I go there and try to register Mickey Mouse when I didn't create Mickey Mouse, I don't have any rights in Mickey Mouse, that's fraud. And my registration, of course, should not stand. But if I created the work and the work's original and I just ticked the wrong box, then an infringer should not be able to evade liability based on that technical issue.
And this resulted in one of the more interesting oral arguments and interesting opinions that had come out in a little while. And so I will just read one bit of Justice Breyer's opinion here and say that, so Justice Breyer said, suppose that John, seeing a flash of red in a tree, said, there's a cardinal, but he's wrong. The bird is not a cardinal, it's a scarlet tanager. John's statement is inaccurate, but what kind of mistake has John made? John may have failed to see the bird's black wings. In that case, he has made a mistake about the brute facts. Or John may have seen the bird perfectly well, noting all of its relevant features, but not being much of a bird watcher, he may not have known that a tanager, unlike a cardinal, has black wings. In that case, John has made a labeling mistake. He saw the bird correctly, but does not know how to label what he saw. Here, Unicolors' mistake is a mistake of labeling. But unlike John, who might consult an ornithologist about the birds, Unicolors must look to judges and lawyers as experts regarding the proper scope of the label single unit of publication. The labeling problem here is one of law. Does that difference matter here? We think it does not. And the upshot for this is that this is one of the most significant victories and important cases for copyright owners and photographers and creators that has come around in a few years. And what is the bottom line? As long as you, the registrant, the copyright owner, makes a good faith effort and are not working to defraud the Copyright Office, a mistake of fact or a mistake of law on your registration will not invalidate your protections and your registration. I want to say thank you, Scott, for your work that you did on this. But any final thoughts about Unicolors and that case and that experience?
Yeah, in the years since, luckily, it's been cited by a number of courts where folks have made that same argument. Look, we may have copied from you, but your registration has an error. And we now have this great authority that the courts rely on to reject that argument and allow the copyright holder, the creator, to move forward with their case. And so, what I always tell people is that even if you get into the application and it looks complicated or you're not exactly sure about something, do your best, act in good faith to complete everything truthfully. And it's 1,000 times better to have an application, even if you make a good faith error, than it is to give up halfway through. Because I've had folks call me and say, look, I've got this great case and I was going through the registration process years ago, but I got kind of confused and I let it go. And I say, well, giving up on that application may, really did decrease the value of your case. And so really don't be discouraged by the Copyright Office's website or some of the questions on the application. Just work through it, do your best. And if you act in good faith, you'll be fine if you have to go to court someday.
Well, thank you, Scott. And now let's turn to something that I would say, I don't know about you in your office, but we started getting questions about and they have not stopped, and that's generative AI. And it's what photographers want to know about for all the reasons you can imagine. It is a significant shift in the way that media is created and consumed. And it is obviously having a significant impact on the world. And so when we talk about generative AI, what we're talking about is two main things. And this is kind of how we break it down from an ASMP perspective. We have the inputs, which go into those large language models and other systems. And you often hear called training. I don't care for the word training. I prefer the word theft. That feels more appropriate in this context. because as you've often heard me say, we are at the tail end of the largest theft of intellectual property in the history of the world. All of us who are photographers and those who aren't, who had images that were on the internet in the last few years, are now part of generative AI models. And none of us, as far as I can tell, were asked if we wanted to be. And we're going to come back to that in a minute. That's the first half of generative AI. The second half are these outputs, and that's what is the copyrightability and what are the elements that attach to an output from a generative AI model. And we're going to spend most of today talking about the inputs and the training, because there have been some big court cases that have come down on that lately. But real quickly, let's talk about what the U.S. Copyright Office has said, because we do have a few questions about this. And I think probably the best way to lead off into the talking about the outputs is by reading one of these questions, which is it possible to copyright an image that is created that features an original portrait with an AI background? And the reason we picked this question, to lead into this conversation, is that the U.S. Copyright Office has been steadfast in their assertion that in order for a work to be able to have a copyright, it has to have a significant amount of human creation. A purely generative AI work is not eligible for copyright protection. Now, we are in a tricky world, aren't we? Where when we open up Photoshop or we open up any program, the tools that we use may be using generative AI elements behind them, and you may not even know. Now, while I applaud the Copyright Office for maintaining that human creativity is a critical part of copyrightability, which is obviously what we believe, the Copyright Office has also made it incredibly cumbersome to follow their rules if you do have any works that also include any kind of AI elements in them. You can watch some other videos that we've produced about this, where right now, what the Copyright Office says is that if your work has AI elements, as this question posed, a original portrait with an AI background, you can get a registration, but only on the part that you created, not the part that was created purely with generative AI. So you're supposed to disclaim the AI part in your application, in your registration. But the only application that allows you to disclaim is the standard application, which means that you can't use that 750 image group application and still disclaim AI generated parts of your work. And that takes your price from $55 for 750 images to $35 per image, which is obviously untenable. Sidebar, that's also one of the things that we focus on in our advocacy work, is helping the Copyright Office create new rules and procedures about these types of issues. But Scott, from a purely legal perspective, what do you advise to photographers who have original elements and they may have generative AI created elements in their work? How would you advise them to think about copyright registration and copyrightability, and what if all I do is use generative fill to take out a blade of grass in the background? Does that mean my work is not eligible for copyright protection? Where does the line fall?
Right. Yeah. And before we started, a question that I'm getting all the time now on AI are those that have to do with opting in when you're submitting for things. And that's something that everybody should keep an eye on. I know nobody likes to read the terms of use when you're putting something on a platform or entering a contest. But a lot of these platforms now are including language in their click license that says, you authorize us to use this for training LLMs, or you authorize us to do basically whatever we want with it. And so it's extremely important. And I know everybody hates it. Nobody likes to do it. but it's extremely important when you're submitting your work in any capacity for a contest, on a platform, for anything, to read that language and see if you're comfortable with it. Because we had someone just recently who had his work used without consent, and we looked into it, and when it was submitted on a particular platform, he had provided the consent, and that's something you don't want to do. You don't want to give away your rights without knowing. And you may say, well, Scott, earlier you said I had to sign something to give away my rights, and that's true for ownership, but for licenses, that's not true. You can give away a license by clicking a button, or folks are sometimes even employing digital signatures to take ownership now. So be real careful. But when you're talking about, especially in photography, we've been saying this for years. If you're using Photoshop, or if you're a graphic artist using Illustrator, you've really been using AI for a long time for doing things like color adjusting and filling, and it's not necessarily new in that regard. But now we are supposed to draw a line between what's human created and what's machine created. And that human element, goes back to, there was a famous case years ago where a monkey took a selfie, and that went to court, and the court said, look, it's pretty clear in the Copyright Act, only humans can be authors. And so, you need that human touch. And there have been a few cases that have moved through the courts or through the Copyright Office procedure, one of which involved a comic book where the art was generated, but the text was not. And the Copyright Office said, well, you have to limit it to the text. You can't have a copyright on the art, but you can have a copyright on the text. And the same would be true in the question, at least. If you have a photograph that you've taken of a subject and you place it on an AI background, you're going to disclaim the AI background, and you're going to take copyright in the photograph. Now, eventually, it may come to be that if you're the combination, right, of the unprotectable background with your subject may also be protectable, and they're going to have to update, particularly as Tom mentioned, the group photography registrations to reflect this. But that may also be subject to protection. But now, if you are submitting something and a blade of grass is removed, I don't think you have to disclose that as a limitation. If a few blades of grass are added, technically you may have to say a few, those blades of grass are not original to a human being, to me, and they should be limited. Though the counter argument to that is, well, those blades of grass, they're often generated from data that's in the photograph that you've taken. So it's arguably a derivative of your photograph. And so you may have that right because the human authorship is in the original that's been turned into that derivative element of your own work. But this is developing. And so to be safe, I would disclaim anything that's not human generated.
Yeah, and I absolutely agree, Scott. And I want to back up to where he started by checking a box that allows your work to be used as training materials or anything else. I think it's important. And ASMP is adjusting its template contract language to include AI clauses that say, that these works are not being licensed for AI training use. That is just like with copyrights and licensing. If a client wants a complete buyout and a very broad scope license, it costs more. If a client wants to use the work that you create for AI training purposes, that is a line item element that you as a business owner can choose to license or not license, but it is yours to license or not license, right? That's the bottom line. And so we're going to help provide you with language for that, that you can put in your contracts. But as Scott said, always be careful. Contests are particularly notorious for this right now, as Scott was mentioning. Over at ASMP, we've drafted the model rules for contests that we use on all our major contests, including Best of ASMP, which is coming up a little bit later this month. And we encourage other organizations to use those rules as well, that reserve rights to the creators and prevent works from being used in ways that are outside of the scope, and certainly being used for AI training would be outside of the scope. So good question. Good question. Okay. So let's talk about some more training elements, because there's a case that we've gotten a lot of questions about. You all may have heard about in the news lately, and that's this Bartz versus Anthropic case. And we'll quickly run through some of the background on this. And I want to give a particular nod to Alicia Calzada, who assisted and helped create some of this information that we're showing here today. This case is between book authors and the company that owns Claude, the LLM Claude. And in June, there was a court case where the author sued and said, you know, you illegally used the works that we've created as part of your training, as part of this generative AI platform. And there was a court case that went through a number of months. And in June, the judge held that several occasions of Anthropic's copying of the books were considered fair use. Now, including those involved in training of the large language models, we disagree strongly with that. Let's make that clear at the outset that, you know, we don't believe that in this context and the facts presented that this was any kind of fair use. That being said, that wasn't the entire ruling. The judge also held that it was not fair use when the company downloaded a massive set of pirated copies of books and used those copies to build a central library for its own use. And while we don't know all the details for each and every company, I have to assume that that was a widespread practice as generative AI models were being created, that there were these large-scale stolen databases that were used to train. On July 17th, the judge certified a class action in the case, and there was a settlement reached between the parties and Anthropic. And a few weeks ago, that settlement was announced for $1.5 billion, billion with a B. And this doesn't just apply to authors. If you're a photographer who is the listed author of a book, you may very well be in this mix too. And, you know, you might want to go check. So how do you go check? Well, let's take a look. You can go over to the official website of the Anthropic copyright settlement website. And it asks, are you the legal or beneficial copyright owner of a book included in this settlement? And you could get a payment from the $1.5 billion settlement. Well, I found this very interesting because we went to look up a work and I just typed in American Society of Media Photographers. And lo and behold, our latest edition of ASMP Professional Business Practices in Photography, the 7th edition, was included in this. It was included in this stolen set of works. And so what do you do if you find that your work was included here? Well, first, you write down all of this information because you're going to need it in a second. Then you go up here to the File a Claim button, and you can fill out a claim form. You have until March of 2026 to fill out this information if you do find yourself on this list and it asks you all these questions. So it's worth going to check because depending on the number of claimants, it is a very large settlement that they entered into. Now, that's the happy part. Here's the rough part. And Scott, I'd be interested to get your opinion on this. One of the very concerning things that I first thought when I heard about this settlement is that when there's a settlement, there's not a chance for appeal. And we had a situation where, you know, part of this was found to be fair use. And now, you know, that is the law that's on the books. What do you think other courts are going to find when it comes to training and fair use as we look past this Anthropic case and to the ones that are coming up next?
Yeah, well, a couple of things about the cases that have come down so far. You're absolutely right. If you settle the case, there's no appeal, but the case is a district court decision, and as district court judges will always remind us when we try to bind them with a district court decision, they say, look, that's my colleague down the hall. I'm not necessarily bound by them. I'm going to look at it on its own merits. And so we don't yet have this appellate precedent, though in the Thomson Reuters case, we may get some of that soon. But I think the court took pains here to sort of cabin the ruling and make sure that other folks don't rely on it. And one way they did that was by saying that the plaintiffs in the case didn't do enough to establish market harm. As we know, from the Warhol Supreme Court case, when you're looking at a fair use defense, really it's the market harm. Will allowing this type of use negatively impact the ability of the folks that own the underlying work to make a living or market their work? And one of the judges said, just looking at it, of course, this could decimate the entire industry. If we could make a countless number of works without their consent, then it'll be absolutely horrific in terms of impact. But there was no evidence of that really put forward by the attorneys, and that it's not great. They should have put that evidence together. But the judge in the case did seem to reverse the burden of proof. Usually, if someone's claiming fair use, the burden's on them to prove that each of the factors favors them. So really, if the law had been applied correctly, the defendants in the case would have had to come forward and say, look, we can do this and it won't hurt the authors. We can do this and it's not going to impact their market. And if a bunch of other folks also start doing it, it's not going to impact the market. No, I don't think they could have done that, right? It's just facially an argument that it would be hard for anybody to swallow. But the judge really called the folks out on the plaintiff side in the case, and the Meta case, which we may talk about, and said, look, you didn't do enough. But really, the more interesting issue that I think will get litigated as some of these other cases, including the Anderson case and the Getty case and some of the other cases involving photographers here and overseas, start moving through the process, is that really the point of transformation and why transformative use is an element of the fair use analysis is because we want to encourage people to add creativity to underlying works. The paradigmatic example of a fair use work is a parody song. If you release a song and I create a new song that comments on that song and is interesting and new and adds new creative content, that's the type of thing you want to encourage. But here, when the courts have thus far done the transformation or transformative nature analysis, they haven't really looked at that. And I couldn't tell if it's because the lawyers maybe didn't argue it specifically or what, but really the court should be looking at what creative content, what copyrightable content are the defendants that are claiming fair use are adding. And here, as we know from what we talked about earlier, this is all machine generated. So there's no copyrightable content that's being added. And so unlike a parody song, or some of these works where an author really builds on the underlying work and adds copyrightable creative content to the underlying work, here nothing is being added. It's just simple aggregation, which to my mind is far less transformative than the traditional types of transformative works that I mentioned. And so I hope that gets ventilated more, in some of these other cases that are pending. But those are some of the issues that I see with those rulings.
Well, and you mentioned a few times, Scott, such a critical piece, that transformative element of fair use, and fair use analysis is tricky. It's not, it's a holistic analysis. There are factors, but there's not one factor that's dispositive, right? So we have to look at it as a whole. And the case recently that we both mentioned a few times is the Warhol versus Goldsmith case. When Goldsmith, of course, being an ASMP member for many, many years. And this is the case that ASMP was proud to work with her on, because it came out, the Supreme Court had some strong law and opinion that came from this, where, it was talking about how things can't be just a mere copy. They have to have this creative element to be considered fair use and be considered transformative in those ways. If you want to hear thoughts about this more than you want, I will put a link in the comments where you can go watch a live stream that Jeff Sedlick and I did for about 3.5 hours of the opinion being released and talking about our thoughts on the case. And so definitely go and check that out if you're interested in this. Thank you, Scott. I think that it is, and we've been saying this now for about a year, it is still in the very early stages of these cases. And we don't know what different courts will do. And in the US, different circuits treat things different ways. Scott and I deal a lot with the difference between the Ninth Circuit and the Second Circuit and the Fifth Circuit. These are areas of the country where courts are, and they have different views on copyright and different views on these types of situations. And so we're going to be keeping a very close eye. I did want to ask a question, and Scott, feel free to politely demur if you prefer not to answer. But it's come up a few times, and that is, we get the question: why isn't ASMP? Why haven't we signed on to one of these cases? Why haven't we, recommended that photographers get involved in certain class action cases? And I wanted to take a point here to say that it is important to consider the quality of the attorneys who are involved in a case and their experience in these areas. Some of the class action suits that immediately came out that included, some of the photographers were quickly thrown out of court, right? And they were thrown out of court for reasons that a seasoned copyright lawyer wouldn't have passed. They would not have gone down. What is your recommendation to photographers or creators right now who are hearing about all these class action cases? Maybe some of them might be eligible for a class. Should they be pursuing that? Should they be cautious? What are the implications for that?
Right. Well, that's the notable thing about these class action cases, where you can opt in or opt out depending on how it's structured. And you want to consider a number of things, whether you believe that the attorneys handling it are doing so competently. I mean, that's one of the things in the Cadre v. Medicates that the court basically called out. They said, look, you guys made the wrong arguments. You didn't develop the right ones correctly. Pretty harsh words for the parties and their counsel there. And so, I used to say that it's better to bring the claim even with an attorney who may not be the perfect fit. But now my positions have shifted because, there's certain attorneys that have brought cases where, the rulings have been poor, and, that may have been a result of their advocacy. And what happens with those poor rulings, notwithstanding what I said about district court judges not necessarily having to follow their colleagues, is that a lot of the times they're persuaded by it. And we don't want to have a situation where, folks are making bad law. And so I'm actually a member of, a quick plug, the National Society of Entertainment and Arts Lawyers, who we work with and on the same side as ASMP on a lot of these issues. And that organization, one of the aims there is to help other attorneys or help folks looking for an attorney find the right attorney, or if it's an attorney that wants to help artists present the case, correctly. Because it truly is a thing that a good ruling, like the H&M ruling, for example, that really does benefit every artist in America, because they can then rely on it when they go to court. And so, I specifically in connection with the pending class actions, I don't want to pass judgment on any, of the folks involved. I will say that if you opt out and you bring the claim on your own, that's going to be pretty difficult to do, just because the damages available to a single plaintiff in a case like that, may be so modest that you'll spend more on the case than it's worth. But it's only solidified my position over the last couple of years that really, when you have a legal case, you should try to find an attorney with a background in copyright law. And you can call ASMP, you can call me, and we can steer you in the right direction. But that is something that's hugely important.
Thank you, Scott. And I think that echoes a lot of what, and I'll just talk personally, what I think, here as the CEO of ASMP. I think it's very important with an organization that does have 80 years of track record behind it to associate itself on cases that are going to make good law. It's sometimes not about an individual result. It's about how does this serve the industry, and how does this move the law forward to something that's more equitable and more fair for creators. And that's something that that we take seriously, and it is a responsibility. Now, all of that being said, just like we saw in the Bartz case, if there are cases that do come down where there are settlements where creators can be compensated for these types of training thefts, by all means, pursue that in the ways that I just showed you online, because ASMP sure is. We're gonna fill out that form and see what comes of it, and we'll let you all know what comes of it. I wanted to, in the last few minutes here, I wanted to just pose a few more questions, I think, and then at the end, I'm going to draw some names for some giveaways of 80th anniversary merch. So I hope you have entered into the giveaways, which you can find at asmp80th.org. And we're also going to talk about what event number 3 is going to be. This is event number 2. Event number 1 was in Chicago last weekend. Event number 3 is occurring a week from Friday on October 24th, and it's kind of exciting. I'm really looking forward to it. I'm going to talk about that in just a minute, but right now I want to see if we can answer a few more questions. This is a question, Scott, that we get asked in a number of different kinds of ways. How can artists and creatives calculate estimates on whether their copyright infringement are worth going to trial or accepting a settlement? Litigation can be very expensive. So how does that factor into whether the statutory damages are worthwhile?
Yeah, I mean, this is an extremely important factor. As attorneys, we will generally look at 3 things when an artist reaches out to us for help. That's liability, can they win? Damages, what's available if they do win in terms of monetary damages or other damages, and then collectability, who is the defendant? Are they domestic? Do they have a tie to the United States, or are they elsewhere? Are they a legitimate business or not? That sort of thing. But damages, are always going to be on 2 tracks under the Copyright Act. Section 504 controls, and it says, if you have a timely registration, you're entitled to seek up to $150,000 per infringement. If you don't, you're going to be looking at your actual damages plus the infringers of the profits of the infringer. And so we look at things like your licensing history, similar deals that you've made in the past. And then also, how has the infringer profited from your work? If they're selling merchandise, you can look at the profits on the merchandise. If they're using it in a larger work, you can look at how that was sold and marketed. And, we'll take that data to figure out, what we think the range of damages is going to be at trial. And you can generally get a relatively good sense of what those actual damages are, the damages that relate to your lost licensing history and disgorgeable profits. Statutory damages is a little bit more difficult because the judge or jury will be given a range of up to $150,000, and they can come down, anywhere within that range after considering a number of factors. One of the most important of which is how willful was the infringer. Were they a real bad actor? Did they know what they were doing? Or were they innocent or potentially just reckless? That state of mind is important for statutory damages. But it can be a great disparity. I always tell the story about a case I had early in my career that was over a busted license. The license was worth $2,000. So my client's damages were $2,000 on that license, but it was a longer term client. They had a timely registration. And we took the case all the way through trial, and the jury awarded the client $150,000, after which the client was able to seek their attorney's fees as well. And so it's another example of why registration is so important. But it does show that really there's a lot of discretion that the judge or jury has to set that statutory damages amount. On the actual damages, there is this almost inverse set of circumstances where the better the infringer does in infringing, if they're selling infringing goods, for example, the larger the damages will be. So that is sort of a strange structure, because in a way, you're looking at the infringer and saying, are they good at infringing, when you're establishing your damages. But an attorney who's been around the block a few times should be able to tell you, whether or not a settlement is the right move as opposed to going to trial. I can tell you that in our firm, we've done over 5,000 artist disputes over the last 20 years. We've been to trial in these artist cases about 20 times. And that's actually a large number of trials, more than just about any other firm in this area. And that really shows you that 99.99% of cases settle before getting to trial. And so oftentimes that is the way that these cases will resolve. But if you believe in the case and the damages are there and you've consulted with your attorney and you believe in the attorney, then take the case to trial.
And that 99.9% of cases that settle, I want to reiterate the fact that the best way to get a positive settlement is to have a timely registration. That is the cudgel with which you get your settlement. That's the thing that brings the other side to the table, right? And so these aren't, you might hear that and think, well, if nothing here goes to trial, then I don't need to jump through all those procedural hoops. Those hoops are what let you get those positive settlements. And so, you really want to be thinking about that as well.
I just want to note one little nuance there, because I look at the question and I want to make sure that we're using the same terminology. Going to court and going to trial are two entirely different things. Filing a case with the court starts the litigation process, but even though the case has been filed, those cases still oftentimes settle before getting to trial. And so I just wanted to, sometimes when I talk to folks that we conflate those two terms, but going to court, you file the lawsuit, going to trial is when you're in front of the judge or jury 12 to 18 months later in most jurisdictions.
That's a really important distinction, because so much of, when you retain a lawyer, so much of the work is done in that time between filing the lawsuit and then when there might be a trial date. That's where we hear about the things you see on TV, like discovery and depositions and, expert reports, and all those things occur in that interim before trial.
And I can say that if you're an artist that has a case, about you see on depositions, and so giving a deposition or participating in a mediation or going to trial, at the end of it, they're actually quite happy about it, and they really had a great time doing it. Because as the artist, you're getting in there and telling the truth. There's nothing, much to be concerned about. And of course, you're well prepared for everything, but it's not, that onerous of a burden. Maybe on the attorneys, but not on the artist. So don't let that dissuade you from bringing a case.
Yeah, I'd agree with that. If you enjoy talking about what you do and the passion behind it, depositions can be fun. If you're the creator, the photographer. Last question here before we do some final announcements and some giveaways and some other things, and it goes back to something we were talking about a minute ago, and it's a less than a 2-line question that has answer that is far longer. Is there a clearly defined definition of what fair use actually means in the law? Scott.
No, there's no definition. There's a number of factors that the courts should look at. And as I mentioned before, the most important one is market effect. And the second most important one, arguably, is how transformative is the work. But, judges and, folks commenting on fair use, nobody seems to have a consensus on how it's applied. Since Warhol and since a case that we actually were fortunate enough to win, McGuckin versus Pub Ocean in the Ninth Circuit, which binds all of the West Coast, proving fair use by a defendant who's really using it commercially and not adding all that much to it is now far more difficult than it was a few years ago. And so the defense is certainly still out there, but especially as a photographer, the case law over the last few years has really swung in your favor.
And I'll end by saying something about fair use that I think a lot of people don't, because fair use is put up as a shield all the time. The minute there's threat of an infringement, but fair use is a defense to infringement, which means that by the time you say, yes, it's fair use, what you're also saying is, yes, I infringed, but it was okay because, right? And I think that, the understanding of what fair use is tricky. And there are now, especially with so many AI-oriented systems, there's automated searching. There are all these things that are occurring, which you might be on both sides of. And I'll give you a good example. At ASMP, we get notices about webinars we've done that have, infringing copyright content in them, whether it's music or something else. And, under strict fair use analysis, even as an attorney, my argument would be that we're making commentary and critique on these things and we're doing, that doesn't prevent them from saying you can't do this. What it does is it puts the onus on me to prove that I can, which really isn't the way that fair use is designed to be used in the way that we normally think about it. But there isn't a clear answer, as Scott said. But what there is a clear answer to is how appreciative we are to have you here today, Scott. And thank you for all your knowledge and all your expertise. And I hope that everyone here and everyone watching on all the various live streams was able to get their questions answered. And we certainly appreciate you being here. Thank you.
It's a pleasure as always. Thank you for having me and allowing me to be part of this great event.
Well, Scott, hold on one second, because we're going to give away two things, and then we're going to talk about our next event, which is coming up. And so we're giving away 2 limited edition 80th anniversary ASMP T-shirts right now. And the first is going to K, last initial C, out of Dallas. So K, congratulations. We'll be reaching out to you. And the second is going to Alton. Last initial M, out of Frederick, Maryland. So congratulations to you as well. That's how easy it is to win a giveaway. You just go to that thing and you fill it out, and then I hit a button which says give me some winners, and I call your name and you win stuff. Everything from shirts to equipment and everything else. But what I wanted to end on is our next event number 3. This is a virtual panel occurring a week from Friday. It's called Inside the Room: How Creative Directors Really Decide Who Gets the Job. What it actually takes to stand out, get hired, and stay booked in 2025. This is an area that we get asked about all the time. It's being moderated by Karen Williams, a photo director, worked for everyone, also author of the book, The Photo Hustle, which is amazing. And a really top-notch set of panelists. Some of those names I am sure that you recognize there, and even more may be added as we get closer to next week. That is free. That is part of the ASMP 80th anniversary. We're going to look at some archive stuff. We're going to do some giveaways. Same kind of stuff we did here tonight. Registration for that will open in the next 48 hours, so you don't want to miss that. Be sure to register. We'll also be live streaming it just as we did tonight on Facebook and LinkedIn and YouTube, of course. Please go and visit all our channels, check out the mini site. We're working real hard to make the 80th anniversary something special for all of you, both members and non-members alike, and we really appreciate you being here today. So with that, I will say, Scott, thank you again. And to all our members and non-members and everyone watching, thank you all. We will see you next week for the 3rd event here in the ASMP 80th anniversary series, and we will talk soon. Thank you.